Principals are notified, and oftentimes on these H's and I's, the children are getting suspended, and the place they need to be is in school. What this simply says is that the principal makes the individual determination as to whether or not they need to be there after they've been charged with that H and I, as opposed to an automatic suspension, which oftentimes happens whenever they have an H and I charge. And a lot of times that's not the best thing for these juveniles that are already kind of on the wrong track. So commend the bill to you. Again, this PCS, and we'll be back on next Tuesday for a vote. I think we have some speakers.
Before getting to that, I did neglect to welcome our two House members to this committee, Representative Davis and Representative Torbett, and thank you, gentlemen, for graciously allowing to use your bills for these fine policy pieces. Any questions or comments from the committee? I see Senator Mohammed.
Thank you, Senator. Thank you, Senator Daniel. Questions for the bill sponsor, Mr. Chair. Senator Britt, I remember last session, I think strengthening juvenile law, that I talked to Mr. Spejos with the Conference of DAs. I thought we had already worked to resolve the transfer issue.
We did, and we passed legislation that should have addressed it. There's been an opinion from the School of Government that that didn't necessarily address the issue, and that there still has to be that hearing after the indictment. So that's one of the main things we're trying to do with this, is to clarify that issue. And Chuck can probably speak more directly on that, as well, as far as what's been happening and how that's been played out.
Follow up, Mr. Chair.
Yeah, you're recognized for a series.
Thank you, Senator Britt. So I guess my concern is if you, I guess what the bill does is divest jurisdiction of district court. My concerns are when these kids are already arrested. I mean, we call them detention. We have fancy words for kids, but it is prison, it is arrest, all those things. All those things happen to kids. If we divest the district court's authority, now we're essentially allowing OFAs to be issued. My concerns are about the burden that it also puts on law enforcement, because now they've got to apparently go back and pick up this kid who's already at a juvenile detention facility, rearrest them, bring them, get them fingerprinted, booked, and all that. We've got issues of appointment of counsel. I feel like we're making it more convoluted with this. What this is doing, if we're trying to streamline the process about how once you find probable cause and the kids automatically get transferred to adult court, can't we figure out other ways to do that instead of creating more work, which juvenile justice wasn't supposed to do?
Right. So this actually doesn't do that, and it doesn't do that in the sense that you're already getting a court-appointed attorney. Rather, you're getting a court-appointed attorney in Superior Court or getting a court-appointed attorney in juvenile court, right? So you're entitled to a court-appointed attorney at point of charge. So that doesn't change. You get a court-appointed attorney. It does make it easier on law enforcement to be able to take these juveniles who have committed violent acts, and it spells out first-degree murder, assault with a deadly weapon, intent to kill, inflicting serious injury, discharging weapon in occupied property, assault with a deadly weapon, inflicting serious injury, assault with a deadly weapon, intent to kill, assault with a firearm on law enforcement officer, discharging weapon in occupied property, and we do intend to include crimes of rape. What this allows is for an order for arrest to go out against that juvenile instead of a petition, which actually makes it easier for the law enforcement officer to go in somewhere and put this dangerous person into custody.
But Senator Britt, again, with these types of offenses, the kid's more than likely already in a detention facility.
Not necessarily, because they're out of custody, right? They commit the offense, and then they get charged. So we're talking about people that are getting initially charged with one of these violent crimes. They're not in a juvenile facility.
So you're saying
I'm talking about this is somebody with a new charge that's getting this order for arrest for this charge.
What you're saying is when somebody gets a brand new offense, this is what would happen? Or are you talking about when the kid, because
talking about
the juvenile stuff to come through the juvenile, but if somebody's already under juvenile court's jurisdiction, aren't they going to come through juvenile court already?
If they're already under juvenile court jurisdiction and they're in custody for another offense that is separate from the offense that they're being charged with now, then yes, in theory, if that person is already locked up on another offense, then they would have to go to juvenile detention to get them out of custody, as opposed to having to go out in the community and get them or go get them from a jail.
Okay. And the other question I have, Senator Britt, is the removal of the 10-day period for the secure custody orders. So the concern I have for that is, like, for example, in Mecklenburg County, we don't have a juvenile detention center here. Oftentimes these kids need those comprehensive clinical assessments. They need different screenings. Sometimes parents can't go visit them at a detention center. I don't know of any 12 or 13-year-olds for, again, violent offenses. I understand we have a different setup for. I think it's 30 days already. But for any basic offense, if a kid isn't sitting in detention in a secure custody order, my concern is that if we remove that 10-day hearing period, that it's going to create more issues, especially if the kid doesn't know that he can request it, because most kids don't. Adults I've represented don't know about the rights.
So
How would a kid know?
So again, the attorney can, and we would hope that the attorney's competent enough to know the law and to know they can request this,
Sure.
just like you can with an adult.
Sure, Senator Britt. And I would love to have full faith in my fellow members of the bar. My concern is a lot of the work, you know this as well as I do, especially in rural parts of our state, majority of this work is done by court-appointed lawyers who are paid very little at our PAC rate, at our court-appointed attorney level. In addition, you've got a bunch of public interest attorneys that are also overworked. So my concerns are these children would probably fall in the gaps unless you found a good district court judge, hopefully, who's willing and requiring at these detention hearings to actually bring this kid back and encouraging it. I just don't have full faith in that. So I think we should continue to have a discussion and figure out what that 10-day period is instead of fully removing it.
Yeah, I also agree we should have competent attorneys. And
I agree.
I appreciate having competent attorneys that can
I would love
read
that.
the law, follow the law, and do what they need to make sure their client doesn't sit there unnecessarily. Whenever the law allows them to come back every 10 days and request the court to look at their pretrial release conditions, I think that every attorney should be able to understand that and do their job. I agree with you totally. Yep.
Any other questions from the committee? Seeing none, we do have a couple speakers that have asked to speak. So let's start with Mr. Billy Lassiter from the Department of Juvenile Justice.
Good morning, committee. Thank you for the opportunity to speak. So right now, I think there are some technical problems with the bill as it's written, and I appreciate Senator Britt and Chuck being willing to have conversations about those problems with the bill. A couple of things that we've just noticed offhand is that last year, 411 kids were transferred to adult court from juvenile court. And so we know that is happening on a routine basis already. I'm confused about exactly what we're trying to fix with that if so many kids are already being transferred to adult court. The Juvenile Jurisdiction Advisory Committee, which you guys appointed, specifically looked at whether we should take single crimes and make them automatic transfers to adult court. That committee recommended overwhelmingly not to do that. There were 2 DAs that served on that committee that said we shouldn't do that. And the reason why we shouldn't do that is because they were concerned about law enforcement knowing exactly which crimes they would automatically send to adult court and how would they handle those individuals. So the purpose of having them start in juvenile court is so that the juvenile court counselor will actually oversee that process and case manage the process moving forward and make sure that juvenile is getting the services that they need, but also make sure that law enforcement knows how to handle those cases. And so we're not opposed to the idea of transfer. In fact, we helped with the language last year to try to get kids transferred that needed to be transferred for those very serious and violent crimes. We just want to make sure that we're not overburdening the system, making this more complicated than less complicated. And so we look forward to working with the committee and with the sponsors of the bills and with Chuck on making sure that the bill is more effective in doing that. Thank you.
Thank you, Mr. Lassiter. And Mr. Spejas, maybe you can shed some light on why you think some of these changes are necessary.
Thank you. Chuck Spejas, Conference of District Attorneys. Thank you, Mr. Chairman, members of the committee. Yeah, the driving force behind this bill is to, quite frankly, clarify what we believed we were doing in the previous legislation, which was once an indictment is returned by a grand jury, which returned is into the Superior Court, we believed that we were placing the case in Superior Court. There have been subsequent opinions that there is still reason and cause for the juvenile court to hold a hearing after indictment. And this would be the only place where we let what I would describe as an inferior court make a decision about what is taking place in the superior court. So this would just clarify that indictment necessarily invest the jurisdiction or vest jurisdiction in superior court and divest it in juvenile court. So that and the other concepts, Senator Muhammad and I have talked, and I'm committed to him that we would look at there's not an elimination of the 10-day continued custody hearing, but it would require, instead of a juvenile being in front of the court every 10 days, when there's not going to be something to accomplish, that it not come and have to be transported every 10 days. But I committed that we could also put some other triggering event in there. Perhaps the court can cause it even if the juvenile doesn't request it. So we're flexible and open-minded. And I'll leave with a follow-up commitment to what you heard from Mr. Laster, that we are committed to working on these procedural parts. I have an open dialogue is going with the School of Government as well to ensure we don't have a repeat of the mistake we made last time. So I'll be glad to yield to any questions, Mr. Chairman.
Any questions for Mr. Spejas? Seeing none, any questions or comments from the committee? Senator Britt, any closing comments?
No, sir.
Can I, Senator Daniel,
Senator Muhammad.
can I make a comment?
We
I-
bring back Senator McKissick, don't we? Because the committee's too quiet.
Well, this is important because this is about kids at the end of the day. Senator Britt, you know this. I mean, at the end of the day, we're all here because we want to be public servants. We want to do a good thing. And in juvenile courts, I try to remind people, are serious courts. Kids are actually punished there. And the great thing about juvenile courts is that you get one judge, you get that one kid, you get the same prosecutor, you get the same juvenile defender. And the most important piece, it's the only jurisdiction where you get to hold parents accountable. You know, we talk about parenting and the importance of guardians and families being involved. We talk about family values. Well, if you want to make sure public safety is involved for all of us, we need to do everything that we can to strengthen and support our juvenile courts. Data, statistics are out there. They show that juvenile courts do reduce recidivism. And I think it's important to point out, and I commend this body, because in 2019, we finally did raise the age. And I want to thank everyone who's in this room who was instrumental in making that happen. But we did that with an asterisk. North Carolina has never actually raised the age. For children with serious and violent offenses, they still go to Superior Court. And we're just trying to make it even more easier now. I got this from DJJ. Just in 2023, 411 kids went to Adult Superior Court. 2022, 351 kids went to Adult Superior Court. So the kids are still going to Superior Court, where they're being punished and penalized. And we have to remember, when you get that adult criminal record, again, that's going to follow you for the rest of your life, unless Senator Britt wants to work on expungements, which I know he loves to do. But it's a critical component. When we started Raise the Age, it was a $112 million ask, is my understanding, to implement it. The General Assembly, is my understanding, only provided $67 million. So we have critical vacancy rates, and I'm glad that this body addressed some of that in the last budget. It's my understanding we still have 32% vacancy rate when it comes to court counselors. Again, another fancy word. That means probation officers, just like in the adult justice system. Detention staff. This is for the safety and well-being of these kids in these facilities, but also the staff folks. We have a 45% vacancy rate there. And when I talk to my police chiefs and our law enforcement community, people talk about the importance of community-based preventions. And we're not doing that. To solve public safety and to make sure that we turn these lives for these kids around, it's going to require all of us, public and private partnerships. Government cannot do everything. But we've got to do our part to support these kids to the best of our ability. So Senator Britt and Conference of DAs, Chuck Spejas, and Secretary Lassiter, I hope we can all come together and do everything that we can to actually preserve our juvenile justice system so it actually allows for public safety. I really appreciate that. Thank you for listening to me.
Senator Britt.
Well, I just want to say I think we have incumbent upon us a duty to make sure that we are doing what we need to do to help these children that are the younger children that are caught up in the system. But I also think we have incumbent upon us to ensure that we protect public safety for those other individuals who are out there in society. And I think that when we have individuals that are this age that are committing violent acts, we need to ensure that they do receive the proper punishment. And what we need to do when doing so is ensure that there is a clear process of how these cases are processed. We need to ensure that there's uniformity across the state in how these individuals are processed and are prosecuted. And additionally, the other part that we intend to add to this is ensuring that those folks that are enticing these younger individuals to get engaged in violent crime are adequately punished for what they're doing as well. And we need to make these clarifications. We need to increase the penalty for these individuals that are enticing these younger individuals to engage in violent crime if we're going to do what we need to do to protect public safety in North Carolina.
Thanks, Senator Britt. Any other comments? All right. Seeing none, these bills will be held and heard on another date, and presumably we'll have some amendments. So the committee's adjourned. The committee's adjourned.